Hi, everyone. And anyone who's who is shy and waiting to come in, come on in. So this session is, to me, the most important session that we have here at the in the Voting Village program. A little bit of history of the Voting Village. In 2017, a number of groups, including attorneys that represented me personally, applied for an exemption to the Digital Millennium Copyright Act, everyone's least favorite law at DEF CON. And this law generally prohibits various kinds of reverse engineering that's routinely done in security research to find security vulnerabilities. There is a process for exempting certain conduct from the DMCA. We asked for an exemption for good faith security research, and to our great delight, it was granted. The nice thing about this is the exemption applies to anyone who is acting in who's doing the thing in the exemption, not to any individuals. So if you're covered by the exemption, you're not allowed to commit copyright infringement, but you are allowed to do the reverse engineering or whatever is cut out as part of the exemption. This exemption specifically called out as an example of things that they wanted to encourage security research in, and they didn't have to do this. Voting machines was specifically mentioned. So with this exemption, Jeff Moss, the person who founds and runs DEF CON, called me and Hari Hursty and a couple of other people and said, hey, what if we bought a bunch of voting equipment and put it in a room and told people about the exemption and said, have at it? And that became the Voting Village, and we've been doing it every year since. But it could not exist legally. The activities in that other room could not be happening if it weren't for that exemption. Now, the problem is that exemption is a little complicated. There are things that you can do that aren't covered by it that could expose you to legal liability. The exemption is also fragile. It isn't necessarily going to be renewed every year. So this is something that needs to be on all of our radar. And it's also something that anybody who's doing security research, particularly on voting equipment where the vendors are all notoriously litigious, needs to understand the ins and outs of. So I'm absolutely delighted that great friend of the village, the EFF, the Electronic Frontier Foundation, whose mission involves protecting all of what all of us do at this conference, and you should, by the way, be supporting the Voting Village. Give us lots of money. All the rest of your money you should give to them. They are terrific people. Tori Noble has agreed to come and lead a session outlining the DMCA security research exemption and an extended Q&A of what your individual concerns are. So please join me in very warmly welcoming Tori for this talk. So, thanks.
Hi, my name is Tori Noble. I'm a staff attorney at the Electronic Frontier Foundation, which, thank you for the great introduction, is an organization that works to protect digital rights across the internet. But one of the things we care quite deeply about, is the rights of security researchers and developers to make sure their products are more secure. And when laws get in the way of that, like the DMCA, EFF challenges them in court. They challenge them before regulatory bodies in rulemakings. They write about it online. They try to push back against those rules with some success, and this is an example of a considerable success. It's not absolute, but this provision, the exception for the DMCA for security researchers, has come quite a long way and has made a big difference. So that will be the subject of today's talk. Like I said, EFF is an organization that works to promote digital rights across the world. We're member supported and would welcome your contributions. If you'd like to learn anything more about it, visit us at EFF.org. All right, just as a disclaimer, I'm a lawyer, but this presentation is not legal advice. If you need individual legal advice, please email info@EFF.org. This is just for informational purposes. Okay, so the overview for this presentation. First, we'll talk about Section 1201 of the Digital Millennium Copyright Act, DMCA, what it is, what it prohibits, and how it may apply. Then we'll talk about the security research exceptions. There are two types of them. One is a set of permanent exemptions that are in the statute, but they're pretty narrow. The second is the temporary research exception that we've heard a little bit about today. But that's the bigger one that is more important to work as a security researcher, but is temporary and has to be renewed every 3 years. Then we'll talk about the impact of these exemptions in the DMCA on security research specifically. So Section 1201 of the DMCA is what's called an anti-circumvention provision. The DMCA, Digital Millennium Copyright Act, was enacted in the 90s as a response to concerns about piracy online. That's why many of the provisions, this one and other statutes, are geared towards preventing piracy and preventing people from finding workarounds for tools that, at the time, entertainment companies were beginning to use to protect the works that they were distributing and to sort of, in their view at least, prevent piracy online. So this is 1201 is really targeting the circumvention of DRM, digital rights management tools. You may see them when you try to, for example, log into someone else's streaming account and can't get access unless you could circumvent it with some bypass method to get around the password field, but that would be a DMCA violation. That's the sort of thing that this contemplates. This was also part of our treaty obligations in the 90s as part of our World Intellectual Property Organization treaties. So that's another reason why this was enacted. But it was never contemplated that this statute would have anything to do with the security of voting machines. That's why over time, more and broader exemptions have evolved to try to carve out that area of research. Because while this statute does go there, it wasn't supposed to. And lawmakers, at least for now, are committed to making sure it doesn't impinge on more of that research activity than is necessary, at least as they see it. So there are two prohibitions in Section 1201 of the DMCA. The first is anti-circumvention under 1201A1A. This prohibits circumventing or bypassing a technological measure that controls access to a copyrighted work. What this means is that you can't, circumvent something, right? It has to be a measure that's there. Just copyright infringement without circumvention is not a DMCA violation. You have to circumvent a protection measure, and that measure has to control access to a copyrighted work in a way that implicates copyright. So if your technological measure, for example, just restricts the location where you can view a video, but doesn't restrict who can view it or what they have to do to view it or anything like that other than just location, that doesn't implicate one of the exclusive rights of copyright. So that's okay. But if you have a rule or a protection measure that prohibits viewing the content altogether unless you enter a username or password, or work is decrypted and you have to decrypt it, things like that, that is all circumvention of of a measure that effectively controls a copyrighted work. The next provision, or the other of two prohibitions in the DMCA, is anti-trafficking. This is under 17 USC section 1202A2. This provision makes it illegal to manufacture, offer, or otherwise traffic in any technology that is primarily designed or produced for the purpose of circumventing a TPM. And a TPM is the technical protection measure that was also at issue in the anti-circumvention context. So if you can violate this if you manufacture, offer, make something available to the public, distribute it, or just otherwise traffic in any technology that is, one, primarily designed for the purpose of circumventing a technical measure that protects a copyrighted work, or you're doing manufacturing, offering, trafficking, distributing, et cetera, a good or service that has limited commercially significant purposes or uses other than circumvention, or that was marketed for circumvention. All of these things make it extremely difficult to distribute tools that are specifically used for getting around certain kinds of technical protection measures. Broadly designed tools, things like Google or a text editor, things like that are very unlikely to fall under this because those have other commercially significant purposes or uses. However, once you get to something that's narrowly focused on getting around these kinds of technical restrictions, even for good reasons, then you end up on the wrong side of the anti-trafficking provision. And the difficulty with the anti-trafficking provision is that while there's a pretty strong exemption for anti-circumvention, it doesn't apply to anti-trafficking. So like the rules as stated are pretty much the rules here. There's a much narrower permanent exemption that we'll get to later. But broadly speaking, this has very little protection from any exemption. So at the heart of both of these statutes both of these provisions are effective technical measures. So what are those? If you're trying to figure out what counts as a DMCA violation, you have to know if the thing that you're trying to circumvent is an effective technical measure. So these are technical protection measures, sometimes called TPMs. And these are digital protections that control access to a copyrighted work, and it only applies to measures that protect copyrightable works. Some examples of things that are TPMs would be DRM, right? You usually find this on DVDs, CDs, streaming platforms, things like that. Encryption, CAPTCHAs, authentication handshakes, code signing, and other kinds of technical barriers that direct or control access to a work. The thing here, or the key thing here, is that for it to count as a TPM, it does not necessarily have to impose a significant hurdle, especially something difficult for someone technically minded. It's possible for something to be very easy to bypass and still count as a TPM. So if you conceptualize this as like, okay, well, like what you can't do is hack, right? It's not an anti-hacking provision because the things that you can do that qualify are pretty minimal. But so really, really thin protections count under this. Things that are not TPMs, things that like wouldn't get you in trouble. Basically, if you use a unauthorized, like if you've got someone else's username and password and you use it as a username and password, that's okay because you're still using the TPM that they've given you, which is a username and password. You're just doing it in a way they didn't intend. The other things that don't qualify here are any kinds of technical measures that protect non-copyrightable material. And this, in part, Hello? Okay, cool, thank you. Sorry for the disruption. Examples of things that are not TPMs and wouldn't get you in trouble under the DMCA, under section 1201, are measures that protect non-copyrighted material, and the most important part of that is purely factual information. So if you've just got facts, like a list of facts that are unorganized, not ordered in any particular way, not curated, then that may not necessarily be copyright protected. However, the problem with relying on that non-copyrightable material sort of almost carve out is that it's extremely difficult to know for a non-lawyer whether something will be copyrightable or not, especially when you get in the realm of things like software, technical code, technical information, right? Just facts and statistics, things like that, or even laws sometimes, in some cases, have been deemed copyrightable in some cases. So it's extremely, extremely difficult to make that determination. But in theory, if the thing that's protected is not copyrightable material, then the DMCA section 1201 wouldn't apply. Another thing that's not a TPM are measures that don't implicate copyright at all, copyright exclusive rights for the copyright holder. And this is what I mentioned earlier about limiting access to a physical location. That is not an exclusive right under copyright, so does not add issue here. And then so now that you know like what the TPMs are that you can't circumvent, then the question is, what is circumvention? Essentially means what it sounds like. It means removing, deactivating, impairing, bypassing, working around a technological protection measure, like, for example, decrypting an encrypted work. And without the permission of the copyright owner. So circumvention is effectively a permissionless workaround or turning off. That is pretty much all there is to that. Another thing that makes the DMCA so powerful and covers so much is that there's no fair use defense to section 1201 claims. That means, unlike copyright infringement, there's a defense called fair use that applies to uses of the work that are transformational in some way. You're changing the meaning of the work, you're turning it into some kind of new commentary, new reporting on facts or material that's been gathered by someone else, things like that. And creating new software and using some software to create that software, or parts of functional code to create something new is often fair use. However, the fact that you would be doing or using the material for purposes that could very well qualify as fair use under copyright infringement doesn't have any bearing on whether or not you can claim a defense to 1201. So unfortunately for election security researchers, this matters because election security would be considered a fair use in many cases, in that you are using, if you're reverse engineering, for example, some material or some part of the machine or system, and you use it to figure out whether there's a vulnerability there, or if there is, how to fix it. You're still using and making a copy of that part of the code, but you're using it for a completely different transformational purpose. So if that was a defense, we wouldn't have as many issues, most likely, under section 1201, but it's not. So what a lot of the exemptions have done has been to try to capture a lot of the uses that really should be, the DMCA isn't meant to go after, things that would probably be fair uses, and things like that. But unlike fair use, which can be asserted on an individualized basis or a case-by-case basis, the exemptions for the DMCA for Section 1201 have to be recognized by either the statute or the Library of Congress in advance through a formal rulemaking process. So the penalties for violating this provision. There's civil liability. There's civil liability, which includes injunctive relief and monetary damages. The money damages can be either actual damages plus the profits of the person who violated the 1201, or the plaintiff can elect statutory damages, which are $200 to $2,500 per act of circumvention or per product, service, et cetera, that is designed for circumvention. And the courts have a lot of leeway here. Additionally, repeated violations incur triple damages. So these can add up pretty quickly to the extent that you're violating 1201 multiple times to, for example, look at a bunch of lots of potential vulnerabilities in different parts of a system, things like that. Those can add up quickly. And then if it happens more than once in a 3-year period, the damages are tripled. In terms of criminal liability, prosecutors can seek criminal penalties if there's a willful violation of Section 1201 for commercial purposes or private financial gain. Usually, criminal liability is reserved for companies that manufacture or distribute tools circumvention tools, basically. However, under the language of the statute, it's very possible for that to encompass security research as well, which is why we highlight it. Anyways, but in practice, this so far has not been much of a barrier or much of a problem for security researchers. If one does end up under criminal penalties for this, for a first offense, the fine is equal to or less than $500,000 and or 5 years in prison. For subsequent offenses, it's a fine of up to $1 million or 10 years in prison, and or 10 years in prison. So they're fairly substantial penalties to the extent they were used to go after security researchers. Okay, the security research exceptions have significantly changed the impact of Section 1201 on security research, especially election security research. There's two different types of them: permanent exemptions, which are in the text of the statute, and temporary exemptions, which are adopted by the Library of Congress every 3 years. So they last for a 3-year period and have to be renewed every 3 years. Unfortunately, the biggest difference is in the permanent exemptions and the temporary exemptions is primarily that the permanent exemptions provide protection for anti-trafficking violations. But the temporary exemption, which is like much broader and usually much more helpful for the kinds of activities that voting machine researchers might engage in, that presumption or exemption doesn't cover trafficking at all. So the two permanent exemptions that are relevant here are the security testing exemption under 17 USC 1201J. This covers good faith security testing, so your access to the copyrighted content and your circumvention has to have been solely for the purpose of good faith testing, investigating, or correcting a security flaw or vulnerability with the authorization of the owner of the computer, the system, or the network. For this exemption to apply, so you need authorization from the computer owner, which is a problem in areas like election security research where voting machine companies don't necessarily want you to do this on their machines. You also, for this to apply, you cannot violate copyright or the CFAA or the Computer Fraud and Abuse Act. The Computer Fraud and Abuse Act is an anti-hacking statute, but it's extremely broad and it's extremely ambiguous. It's routinely litigated in court over its scope and its application. So in the past, the fact that some of these exemptions were contingent on staying on the right side of the CFAA was a very good way for companies to exploit the weaknesses in these exemptions. For example, there was a company called Votes that seized on the fact that a different exemption that had a CFAA requirement, they have to comply with it, that company threatened criminal and civil penalties against a security researcher and leveraged the fact that the exemption, this at the time the temporary exemption was in place, but he leveraged the fact that because the exemption had a CFAA carve out, you had to make sure you were on the right side of the CFAA, which was almost impossible to do given litigation at that time over certain aspects of it. So that dramatically decreases the usefulness of these exceptions, especially when you're dealing with a product or a company that won't give permission for this kind of research. The second permanent exception is encryption research under 17 U.S.C. 1201G. This covers activities necessary to identify and analyze flaws and vulnerabilities of encryption technologies that are applied to copyrighted works. If this research is done, one, to advance the state of knowledge in the field of encryption technology, or two, to assist in the development of encryption products. The work must have been, the device must have been lawfully obtained, and there are a variety of factors that determine whether this applies at all. So this is a tricky exemption. The various factors are, one, this encryption research was disseminated in a manner reasonably calculated to advance knowledge or development of encryption technologies, as opposed to in a manner that facilitates the violation of copyright, another statute, anyone's privacy interests, or in a way that causes a breach of security. The second factor is the researcher is engaged in a legitimate course of study, is employed or is appropriately trained and experienced in the field of encryption technology. So it needs to be someone with formal training or a formal professional role. And the third factor is that the researcher provides the copyright owner with notice of the finding and the documentation of the research. And while it's not clear how fast this has to happen, the language of the exemption makes clear that the timing of the notice makes a difference. The problem with the encryption research protection or exemption is that a lot of these factors and a lot of these considerations are somewhat unclear, and this has not been applied or tested in court. So it's not clear how courts would interpret these provisions, weigh the factors, whether they would treat them as hard requirements, how strict, it's unclear. But based on the language of the statute, there are several bars that you have to meet to qualify for that exemption. One thing that is better in the encryption research exemption, as opposed to the security testing exemption, is that you only have to make a good faith effort to obtain authorization. You don't actually have to get authorization. So someone can say no, and you can still potentially rely on the exemption. And then again, of these two permanent exemptions, the security testing exemption is the one that applies to anti-trafficking. The temporary exemption is the one that's made the biggest impact on security research. The 2024 security research exemption is codified in 37 CFR section 201.40B18, which is a part of regulatory law. And so this is all language that was adopted by a federal agency. It was not enacted by Congress, and it's subject to change. And it actually has to be readopted and can be revised every 3 years. So this language here will be good for 3 years from 2024. And then after that, it's up to the administrative agency. This exception covers circumvention of TPMs in order to access computer programs on a lawfully acquired device or machines, or with the permission of the device owner. The access has to be for the purposes of good faith security research. This access may violate the CFAA. You do not need authorization to qualify for this exception, which is one reason it's so powerful. It does not apply to anti-trafficking, and this version of the security research exception is much broader than some of the earlier iterations, which is helpful, but there are still a few ambiguities in the statute, particularly on the meaning of good faith security research and lawfully acquired device. Those two areas still contain ambiguity that sometimes voting machine companies will try to seize on to threaten liability, even when the exemption appears like it should apply. So what does lawfully acquired device mean? This likely includes purchasing a device from a manufacturer or a third party. It is less clear when it includes borrowing a device from a third party. So if you take it on loan or borrow it, that may not be considered an acquisition under the language of the statute, which means that the lawfulness of the device will turn on whether the person you borrowed it from lawfully owned the device. So this becomes a problem in the voting machine context because some voting machine companies have vendor contracts with a term that prevents resale of the machines. So that means if whoever you got the machine was resold it to someone else and then loaned it to you, or honestly, even if you bought it as a resale, that could potentially violate the contract, and if it does, could in theory render the device not lawfully acquired. It's unclear whether that's true because this has not been fully litigated. But that ambiguity there leaves open the possibility that voting machine companies can try to prevent security research by putting these bans on resale in their vendor contracts. So that is one thing to look out for. One thing that can help is getting written authorization from the device owner, if possible. May not always be possible, but if it is, it can make it more likely that the lawful acquisition requirement might be met. The crux of this exception is the good faith security research portion of the language. So what does that mean? Good faith security research requires that the access was solely for the purposes of testing, investigation, and/or correcting a security flaw. The research must have been done in an environment designed to avoid any harm to the public, which is somewhat ambiguous and another source of uncertainty in the law. The information derived from the research must be used primarily to promote the security or safety of the class of devices that you were researching on, or the users of those devices. And the information from that research cannot be used or maintained in a manner that facilitates copyright infringement, which is another requirement. So copyright infringement in this context can defeat this requirement. This exemption, or this language is much broader than it used to be. But one difference between where we might want to see it and where it is now. So the access has to have solely been for the purpose of conducting this research. If you just happen to get access and then use it later for this, that may not be solely motivated by the desire to conduct this research, which is a weakness in the law. It's not clear that that's quite that narrow, but because there's such a lack of interpretation, the legal risk is there. If you were interpreting this, if you wanted to interpret the exception to use it as a guide for your conduct to make sure you're on the right side of it, you would want to make sure that your access was solely motivated for the purpose of doing your security investigation, not that you started doing something else and then ended up there, which is unfortunate because that's still valuable work, but that's something to keep in mind. The other thing to keep in mind is the requirement that the environment has to be designed to avoid any harm to the public. It's not exactly clear what that means, but it likely contemplates things like making sure the way you've conducted your research isn't going to risk some real vulnerability getting out into the world and harming people before it's patched. It won't enable mass copyright infringement by other people. That's probably unlikely in the voting context, but it's possible because voting software is likely copyrightable software. Things like that. So basically, this is a requirement that you follow good practices, risk mitigation measures, and things of that nature. Okay, so impact on election security research. This exemption has been extremely valuable for security researchers, but to sort of understand where the impacts are, it's helpful to look at sort of where it came from. Before 2015, there was no temporary security research exemption, and researchers were forced to rely on the 2 permanent exemptions. Those, while helpful, are not necessarily that helpful because they have so many restrictions, and in particular, there's a requirement that you get the authorization of the person's, or you get permission basically to test on a device. And if someone doesn't want their security vulnerabilities known, they're not going to give it to you. So that's a major limitation that chilled a lot of research. So it was very easy for companies to call up researchers or send demand letters or whatever and say, well, this it might be security research, but we're not going to give you permission, and therefore it's illegal. So that's a problem. To fix that and prevent, it wasn't just in the election security context, but that was part of the problem that the Library of Congress considered when they adopted the first exemption. The first temporary research exemption was adopted in 2015. That helped a lot, but it also had limitations that created problems. In particular, there was a requirement that it's called the no or the other laws limitation, which means that you can't violate another law if you want to invoke this exemption. In particular, that included the CFAA. So other companies, again, Votes is an example, would threaten security researchers by seizing upon the ambiguity in what a CFAA violation even means. Because at the time it was an active area of litigation and there wasn't necessarily a hard answer to it or clear answer to it. And that was a way to leverage the threat of liability against researchers even though the exemption existed. In 2021, the exemption removed the other laws limitation, which made this exemption significantly more useful. So now the CFAA violation, hypothetically, will not prevent you from relying on the temporary exemption. However, you still may have a CFAA liability, but at least as far as this law is concerned, it's not a bar. This has to be renewed every 3 years. So far, it has been renewed every 3 years. I believe it has now been renewed and renewed 3 times, and I think or 4 times, and of those 4 times, 3 times it was significantly broadened. So far, the momentum is towards maintaining this, but it isn't guaranteed. Impact on voting research. So again, the current version of the election security security research exemption enables security research without the need for permission from voting companies, which limits the chilling effect of 1201 to some degree, because the more ambiguity in the provision and the exemptions that you have to rely on, the easier it is for companies to threaten you with litigation and have those threats be effective. And the more likely it is that researchers won't undertake projects because the fear of liability or the risk is too high, which chills quite a lot of valuable research. The 2024 rule specifically highlights the need for critical security research on voting machines. Part of the evidence that supported the rulemakings and multiple rounds of the rulemakings came from election security researchers who documented threats they received from voting machine companies under the DMCA and explained why either renewing the language or expanding the language was necessary to allow the kind of work that they did on voting machines, and explained why it was important. And that had an impact. That evidence, they're called public comments from the election security researchers, were reflected in the actual findings of the agency when they adopted the exemption or the election security exemption. So it made a big impact. That said, there are still challenges with this exemption. It's not bulletproof, and there's still ambiguity in the exemption. There's very limited judicial interpretation of it. To my knowledge, there is no court, as far as I know, there's not a court opinion that interprets the language of this exemption. So it's not entirely clear how a court would apply it. And if there's a dispute about the outer boundaries of the term, it's not clear how that would come out in litigation. Voting machine companies still sometimes exploit the lawfully acquired device rule by adding contract clauses to their vendor contracts, banning resale. The temporary exemption does not apply to anti-trafficking violations at all. So if you want to distribute a tool for circumventing a TPM, or you want to market it, make it available to the public, produce it, develop it, all of that is still unprotected, except under the very limited permanent exemption for security research. But the temporary exemption, the much broader one, does not cover it. Additionally, the temporary research exemption has to be re-upped every 3 years. So this is not guaranteed to stay in the law. So far, the Library of Congress has maintained it and actually broadened it several times in a row, but this has to be reviewed every 3 years. And if the political headwinds change in some significant way, it could potentially shift what the administration is willing to do, because this is an administrative exemption. Additionally, risks remain under other laws. So a CFAA violation doesn't trigger or doesn't defeat the exception for the temporary security exception, but it may still be a CFAA violation, which carries its own liability as well. There's also the electronic communication, or the electronic communications The ECPA, sorry. Yeah, that one. Yes. So protections on stored communications, things like that, those violations are still possible. But in part, there's some state laws also that can be implicated by certain reverse engineering research. And there are other civil common law claims, so things like trespass to chattels, things like that, which are less of a risk. The biggest other risk probably is the CFAA. But at least that doesn't get you in trouble under the DMCA now. Questions?
Thank you so much.
I will answer that next. Sorry.
I'm not intimately familiar with the legal process, but is there any way to get an interpretation of laws without there being a legal case being brought? Like, can you just bring a question to judges and say, hey, we need some interpretation of this because, you know, your group wants to speak for and enable voting security researchers, right? Is there any way to do that?
Unfortunately, to do that in federal court, you need what's called standing, and that requires a case or controversy. It's a requirement under Article 3 of the, Article 3, but it's a hard requirement. Courts are not allowed to issue what's called an advisory opinion. So unless there's two parties with interests fighting about the actual interests, then courts won't weigh in.
Thank you. I've just forgotten what CFAA stood for, so if you could give us the definition.
Yeah, the CFAA is the Computer Fraud and Abuse Act. It's a federal anti-hacking law that often is used to apply to things that are not.
And it's our second least favorite law.
Yeah, we don't like it either.
Hi, I'm Nick. I'm curious about your opinion of the environmental clause of the Temporary Exemption Act, or the temporary exemption, and responsible disclosure. So, like, the best practices for responsible disclosure would be, you reach out to the vendor and you give them a chance to, a reasonable opportunity to repair or address the issue. And then often what happens is if they refuse to do so, then there's like a public disclosure, right? Like, then you just release the vulnerability in the public. But under that environmental clause, it seems like that wouldn't be permissible because it would create an environment where the users might be put at risk. Do you have an opinion on where that might fall?
I think this is often a case-by-case question, which would benefit from like actual legal counsel on the facts of that case. However, under the environment requirement, that effectively is a best practices requirement. So following standard disclosure procedures to the extent that you don't get the manufacturer to cure before that, conducting your research in a way that limits risks that might cause other security breaches, things like that, right? Doing things in sandboxes, like things like common protection measures that these researchers use for these sorts of things. Standard practices are not like a bulletproof legal defense, but they can help at least establish that you've done this in a reasonably harm minimizing manner.
Any other questions? So I'm going to take advantage of the moderator's privilege and ask a question. I run a village in Las Vegas in which we invite people to play with voting machines. It's actually located right here. And we get a lot of attention from election system vendors. And in fact, but we've never actually been directly threatened with a DMCA violation. Instead, what has happened with a couple of major vendors is they've sent a letter to every one of their customers warning them not to cooperate with us because of contractual violations. So that thing you mentioned earlier about how contract law also interacts with this seems very relevant to us. Can you talk about, now, obviously, there are two elements to this. One is they could be sued by the vendor for cooperating with us. They could claim that we have not lawfully obtained equipment. Could you comment on that a little bit?
Yes, part of the problem with this aspect of the temporary exemption is that there's a lot of ambiguity. There's a requirement that you lawfully acquire the device that you're testing on, but there's very little interpretation of what that means by courts. So one possibility is that if you borrow or receive a device on loan from another company who bought it, but that company's sales contract with the voting machine manufacturer had a clause that said no reselling this device, then there's a question over whether that sale, whether that sale was lawful, right? If you can't loan it out or sell it or whatever under the contract a second time, then it's not clear that A, we've lawfully borrowed the device, or that they lawfully acquired it if their violation of the contract vitiated the terms of their contract. Again, that's a big gray area. It's not necessarily clear that that would be a violation, but it's a risk.
Yeah, my mama did not raise a test case, but I'm willing to be one if necessary.
Yeah, this is kind of an unfortunate extension of that. I wish this comment was the opposite direction, but sometimes I haven't seen this with voting systems, but with other systems I've seen issues where you can legally procure the device, but you may not have license to the software or license to operate it, or that those are distinct things, and so something else to look out for.
Hi, Ray Letts. A related field is privacy concerns, and I noticed there was some cases in Texas where they had identified certain voters that had, and how they voted. They had paired up their vote with the person, the ballot with the person. And I'm wondering if you have any comments on how this might relate to the field of study you're talking about. Thank you.
Sure. If a are you saying a security researcher released information about a person and how they voted, or? Okay, well, assuming that's the hypothetical. If a security researcher was disclosing something like how lots of random individuals voted, that may not necessarily be covered by the exemption, because the exemption requires harm minimization and disclosure of the security vulnerability in a way that minimizes harm to the public and to other individuals. So by releasing private information in a way that doesn't necessarily further the project of making the voting machine more secure, like it illustrates that there's a problem with it, but does it help you fix it? And that's unclear, right? So there's a risk there that releasing lots of private information would not necessarily be considered to have done this in a way that minimizes harm to others. On the other hand, it's not clearly a violation either.
All right, well, this is relevant to everything we do here. All right, this is the foundational thing that makes the room next door legal, and it protects both us and everybody who participates in it. And so understanding all the boundaries that we're just talking about today, it was very technical legal stuff, but it's dead on important to us. So please join me in thanking Tori for spending the time with us. Unfortunately, our next session on protecting researchers internationally, our speaker was denied a visa to come and to come to DEF CON, so we've had to cancel that session. So please relax for the next half hour and maybe engage in some good faith security research next door.
Thank you.